I was just looking at some of your videos and just marveling at how, I mean, to me it looked like it was straight down. I'm sure it wasn't completely straight, but it was pretty steep.
Yeah.
Your Honor, I didn't have a chance to interview him. So
Hold on. Approach the bench. Approach the bench.
What's happening now?
Okay. This is bullshit. This is like Binger level bullshit. So the defense objected that all this talk about skiing and the films the guy's been in skiing, this is outside the scope of direct. And the state's response was, well, it's not like we had a chance to interview this guy. Well, of course, he has a Fifth Amendment right not to talk to you. Of course, you didn't have a chance to interview him. He's got a right to silence. And that's why, of course, naturally, the defense just lost their shit. And now they're right at the bench.
Great. Just great.
Yeah. You're not allowed to say that the defendant was unwilling to speak to you. You have a Fifth Amendment right. It cannot be raised in front of the jury at trial.
It's no big deal. It's like only one of the most basic principles of law known to man. And, you know, basic prosecution 101. But, you know, that's fine. Comment on the defendant's silence. That's great.
This is the same thing that Binger did in the Rittenhouse trial, where the judge called him out and started screaming at him.
Since August 25th, 2020, this is the first time that you have told your story.
Yeah, object, absolutely object.
Yeah. Sustained.
He's a Fifth Amendment right. Yes,
and after all of that, now you are telling us your side of the story, correct? Correct.
That's objectionable.
Yep.
Yeah.
Who's going to talk about the case?
Binger might just be a fucking idiot.
Binger's going to get roasted.
Yeah, he's about to get roasted. I've seen this before. This is going to be good.
This is not good.
This is not good.
Cannot.
The reason why the judge is dismissing a jury because this is so bad. That's why.
He knows he just did something bad. He had a sheepish look to the side.
Because he got objected to the first time, and then he went again to say, this is the first time you've talked. He has a right to remain silent. Don't be a scummy prosecutor. What the fuck are you doing?
He's pissed.
Be better. I'm pissed.
Commenting on my client's right to remain silent.
Yep.
Your Honor, I'm making the point that after hearing everything in the case, now he's tailoring his story to what has already been introduced.
The problem to the evidence. This is a grave constitutional violation.
Yes.
For you to talk about the defendant's silence.
Sanction.
This is not permitted.
No,
all right. Let the jury come in, please.
Great constitutional violation.
Right. Can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice.
Sanctions.
You are already.
Because my pants are currently wet.
Astonished when you began your examination by commenting on the defendant's post-arrest silence.
Oh my God.
That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I didn't know what to talk to.
Grounds for mistrial is what he wanted to say.
Yes.
With prejudice.
Don't get brazen with me. I said it couldn't come in, and it isn't coming in. No matter what you think. Commenting on the defendant's pretrial silence, which is a well-known rule.
Judge is pissed.
I'm astonished.
So pissed.
He was pissed an hour ago.
So I don't want to have another issue as long as this case continues. Is that clear?
We're all astonished.
Thank you. Ask the jury.
Know the law and do better.
Fundamental. This is not a gray area. Steve Gosney is in the chat. Objection. Yeah, no kidding. Bad.
We're gonna take a 15-minute recess.
I'm gonna.
John Madden style. You see, the thing is that you have a right to remain silent.
You think the defense was asking for a mistrial right there?
Probably. I would.
It's I don't know. It's I guess you would, right? You can hardly keep yourself from doing it. On the other hand, it's going pretty well for the defense. So
that's true.
They get to an acquittal, the guy's free forever.
Fair point.
That's the sign of a prosecution that just does not have its shit together, folks. They know they're not allowed to do that. They know there's going to be an objection. They're just trying to plant this seed in the juror's mind that this guy, well, why wouldn't he talk to the state if he's innocent? And that's exactly what the Fifth Amendment is supposed to protect you from. really, really contemptible. And it would be nice if we had another. What was the judge in Rittenhouse? Schroeder? Was that his name? If we had another Judge Schroeder screaming, "I don't believe you," at the state, that was great.
You know, don't get into other subjects. Come on, what you're telling me, you're an experienced trial attorney, and you're telling me that when the judge says, "I'm excluding this," you just to take it upon yourself to put it in because you think that you found a way around it? Come on. And you say that you were acting in good faith? Wow. I don't believe that, okay?
Wow.
He doesn't believe him.
Although he didn't do anything about it. Nothing ever happens to these prosecutors that overreach this way. There's never any sanctions, ever. It's
depressing.
No one's ever held accountable. To my knowledge, Binger is still in his job. Last I heard a few weeks ago.
Okay, I interrupted the state's questioning that Ms. Ramos asked or stated that she did not have the time or the right to interview the defendant. Well, the court finds the state does not have the right to interview the defendant.
Of course not, Your Honor. He has the right to remain silent. That is prosecutorial misconduct to go and bring up a fundamental constitutional right like that in front of a jury. At this point in time, I'm moving for a mistrial due to prosecutorial misconduct for commenting on his right to remain silent.
Hold on. The other right he has counsel. Not only does he have the right to remain silent, he also has the right to counsel. He has counsel. So there's no right to interview the defendant. Ms. Romo.
Yeah.
Your Honor, that was not, clearly it was in response to Ms. Moss objecting, and my point was that before she interrupted, I was about to say, and I was in the middle of saying, I would ask for leeway because we didn't have an opportunity to do a pre-trial interview with him.
Well, you don't have that right, Ms. Romo.
Well, I know, but that's why I was asking for leeway. That's all I was asking.
Why would that be cause for leeway?
Okay, but you could, I understand that, Judge, and I respect your ruling. But for them to jump up and down and her to start laughing in front of the jury and yelling prosecutorial misconduct, that's not what I was doing.
Hold on.
And this court knows
kind of a big deal.
Hold on, Ms. Romo. She didn't do that in front of the jury. She did it after the jury.
She was laughing.
Anyway, I'm gonna deny the motion.
She was laughing.
Take a break and we will come back in about 10 minutes. Anything before we continue?
Your Honor, in light of the defense counsel's comments, I would ask for a limiting instruction, or not a limiting instruction, but instruction to the judge to remind
the
jury to remind that the jury has, that the state has the burden of proof and the defense has no obligation, blah, blah, blah.
I'd give that instruction every day of the week.
Comment I made that is offensive to
no,
Ms.
not
Romo. However, I object to a ridiculous, inappropriate, unconstitutional question. I'm doing my job. I'm following the law.
I understand that, Your Honor, and that's why I'm trying to protect her client's rights, to ask the judge to remind the jury that the state has always has the burden of proof and the defendant has no obligation. And the comment, it wasn't a comment, I was referring.
That's how bad the state knows they screwed up. Now they're afraid that, heaven forbid, they get a conviction, it'll be reversed because of this. So she's calling it a limiting instruction. It's not limiting. It's a corrective instruction to correct their own faux pas.
Know the law and do better.